Hey there, and welcome to Study and Prepare with me. I am your guide, and I am so excited you are here. Whether you are a student aiming for top grades, someone preparing for an important exam, or just curious about learning something new, you have come to the right place. On this channel, you will find general knowledge, current affairs, reasoning, English, etc. My goal is to help you study smarter, not harder, so you can achieve your academic goals and still have times for the things you love. Let's dive into today's lesson and start mastering those concepts together. Fundamental duties. In 1976, the fundamental duties of citizens were added by 42nd Constitutional Amendment Act on the basis of Swan Singh Committee report. List of fundamental duties. According to Article 51A of Part IVA, it shall be the duty of every citizen of India to abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem, to cherish and follow the noble ideas that inspired the national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and traditional or sectional diversities, and to renounce practices derogatory to the dignity of women, to defend the country and render national service when called upon to do so, to value and preserve the rich heritage of the country's composite culture, to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion of living creatures, to develop scientific temper, humanism, and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive for excellence in all spheres of individuals and collective activity, to provide opportunities for education to his child ward between the age of 6 and 14 years, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, and to provide opportunities for education to his child or ward between the age of 6 to 14 years. This duty was added by 86 Constitutional Amendment Act 2002. Procedure for amending the Constitution. Provisions of the Constitution can be changed only by the process of amendment prescribed in Article 368. In the case of provisions which affect the federal structure, ratification by the legislatures of at least half of the states is required before the bill is presented to the President for his assent. An amendment of the Constitution can be initiated only by the introduction of a bill for the proposed in the either house of the Parliament. The amendment bill should be passed by each house by special majority more than 50% of the total membership of that house, and by a majority of not less than two-thirds of the members of that house present and voting. Constitution stands amended in accordance with the terms of amendment bill after President's assent is accorded to it. The blend of rigidity and flexibility in the procedure for amendment. The state legislature cannot initiate any bill or proposal for amendment of the Constitution subject to the provisions of Article 368. Constitution amendment bills are to be passed by the Parliament in the same way as ordinary bills. The procedures for joint sections is not applicable to bills for amendment of the Constitution. The previous sanctions of the President is not required for introducing any bill for amendment of the Constitution. The amendment of Article 368 in 1971 has made it obligatory for the President to give his assent to a bill for amendment of the Constitution when it is presented to him after its passage by the legislature. Whether fundamental rights are amendable. In the case of Kesavananda Bharati, the Supreme Court overruled its own decision given in the case of Golkanath and held that the Parliament could amend any provisions of the Constitution, including fundamental rights, in accordance with the doctrine of basic features. The Supreme Court held in the case of Kesavananda Bharati that there are certain basic features of the Constitution of India that cannot be altered by an amendment under Article 368. The 42nd Amendment Act shall be called in question in any court on any ground. This clause were nullified by the Supreme Court in the Minerva Mills case. There are three implications of the decisions in Kesavananda Bharati's case. Any part of the Constitution may be amended as per the procedure laid down in Article 368. No referendum or reference to Constitution Assembly is required to amend any provisions of the Constitution. Basic features and structures of the Constitution cannot be amended. Executive of the Union. The President. President is the head of the Union Executive. The President of India is indirectly elected by an electoral college in accordance with the system of proportional representation by means of the single transferable vote. The electoral college for the President consists of the elected members of both houses of parliament, the elected members of the legislative assemblies of the states, and the elected members of the legislative assemblies of Union Territories of Delhi and Puducherry. Qualification of the President. Under Article 58, a person to be eligible for elections as President should fulfill the following qualification. He should be a citizen of India. He should have completed 35 years of age. He should have qualified for election as a member of the Lok Sabha. He should not hold any office or profit under the Union government or any state government or any local authority or any other public authority. Elections of the President. Article 54. The President is elected by members of Electoral College consisting of the elected members of both houses of parliament, the elected members of the Legislative Assembly of the states, and the elected members of the Legislative Assembly of the Union Territories of Delhi and Puducherry. All disputes regarding elections of the President are adjudicated by the Supreme Court. Nomination for election of President must be supported by at least 50 electors as proposers and 50 electors as seconders. Security deposit for the nomination as President is 15,000 in RBI. Value of the vote of an MLA. Total population of states divided by total number of elected MLAs into 1 divided by 1000. Value of the vote of an MP. Total value of the votes all MLAs of all states divided by total number of elected MPs. The presidential election is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting is through secret ballot. Conditions of President's Office. Article 59 of the Constitution lays down the following conditions of the President's Office. He should not be a member of either House of the Parliament or a House of the State Legislature. If any such person is elected as President, he is deemed to have vacated his seat in that house on the date on which he enters upon his office as a president. His emoluments and allowances cannot be diminished during his term of office. Article 60. Oath and affirmation of the President. The oath of the President is administered by the Chief Justice of India and his absence, the senior most judge of the Supreme Court. Terms of office of the President. Under Article 56, the President shall hold office for a term of 5 years from the date on which he enters upon his office. He may resign from his office by writing under his hand address to the Vice President. He can communicate to the Speaker of the Lok Sabha. Impeachment of the President. Under Article 61, President can be impeached from office for violation of the Constitution. The impeachment can be initiated by either House of the Parliament. The resolutions must be moved after at least 14 days notice in writing signed by not less than 1/4 of total members of the House and passed by 2/3 of the total membership. Vacancy in the President's Office. Under Article 62, the vacancy in the President's Office can occur in any of the following ways: on the expiry of his tenure of office 5 years, by his resignation, on his removal by the process of impeachment, by his death. An election to fill the vacancy due to expiration of terms must be held before the expiry of the term. If the office falls vacant by resignation, removal, death, or otherwise, then elections to fill vacancies should be completed within 6 months from the date of the occurrence of such a vacancy. The President shall not be a member of either House of the Parliament or of a House of the Legislature of any state. If a member of either House of Parliament or a House of the Legislature of any state is elected President, he shall be deemed to have vacated his seat in that House. The outgoing President continues to hold office notwithstanding that his term has expired until his successor enters upon the office. There is no scope for the Vice President getting a chance to act as President in the case. Smart facts about President. V.V. Giri is the only person who can won the elections of president as an independent candidate in 1969. In July 1977, Neelam Sanjeeva Reddy was elected unopposed as no one is field nomination for the post of the president. Justice M. Hidayatullah is the only person to perform the function of a president two times in two different capacities. The first time in 1969 being the Chief Justice of Supreme Court and the second time being the Vice President of India in 1982. That's it for today's lesson. I hope you found it helpful. If you enjoyed this video, don't forget to give it a thumbs up and share it with anyone else who might benefit. And if you have not already hit that subscribe button and tap the notification bell so you never miss out on new tips and tutorials. Thank you so much for watching. See you in the next video.